A Fourth Circuit decision sets up the next potential Second Amendment showdown at the U.S. Supreme Court.
This is Dr. David Schein, and welcome to Business Law 101.
The U.S. Court of Appeals for the Fourth Circuit ruled in August to uphold Maryland's ban on what its law labels assault weapons. The case is Bianchi versus Brown, where Maryland residents are challenging the constitutionality of a 2013 Maryland law that prohibits them from buying or possessing any firearm deemed an assault weapon. That has not been modified pursuant to state law. In other words, an assault weapon, but if it's modified a certain way, it does meet Maryland law. So we're talking about non-modified so-called assault weapons. According to an article in the Daily Signal, the law in question defines assault weapon to include hundreds of specific models of semi-automatic rifles, as well as any other semi-automatic rifle that either one has a fixed magazine capable of holding more than 10 rounds, has an overall length shorter than 29 inches, or has both a detachable magazine and at least two of the following three features: a folding stock, flash suppressor, or grenade or flare launcher. The article goes on to explain that semi-automatic rifles aren't outright prohibited, but Maryland residents are required to buy heavily modified, featureless versions of those guns. The plaintiffs in this case argued that this prohibition on owning virtually all of the most popular semi-automatic rifles in the nation violates the Second Amendment. This ruling is notable since other courts have been holding that anything less than a machine gun, which are banned by federal law since the 1930s, is not prohibited under the Second Amendment. Court rulings have generally held that usual weapons are acceptable, but not highly unusual ones. That, of course, requires some interpretation. The idea of the defenders of what are referred to as AR-15 style weapons is that they are quite common, and they have not been used frequently in the commission of crimes. In contrast, the Fourth Circuit ruled that the Maryland law was only banning military-style weapons designed for sustained combat operations that are ill-suited and disproportionate to the need for self-defense, so that the law helps by regulating excessively dangerous weapons once their incompatibility with a lawful and safe society becomes apparent. However, this is largely at odds with a number of other court rulings around the country and by SCOTUS. Therefore, this is likely to be the next major Second Amendment showdown at the Supreme Court. This is Dr. David D. Schein for Business Law 101. If you've enjoyed this episode, please subscribe on your favorite platform.